I think I should start with sort of a double disclaimer. I'm of course speaking here to you in an entirely personal capacity, and I'm actually relieved to say that I have not myself been involved at any stage in the drawing up or in the negotiation of the proposal on the data protection regulation, which maybe makes it a little bit easier for me actually to make some personal comments from a slightly greater distance. Data protection in European Union law has come a long way, and it might be appropriate to start by recalling that actually the very first case ever in which the European Court of Justice said something about the protection of a fundamental right in the European Union was a case of data privacy. It was the case of Mr. Erich Stauder against the city of Ulm, decided by the Court of Justice in 1969, which was about Mr. Stauder being entitled to free butter. Free butter was a measure adopted by the European Union to get rid of sort of all the overproduction of milk due to some sort of not exactly well-directed measures of agricultural policy that led to this overproduction. Mr. Stauder was a war veteran, and he fulfilled the criteria to get this free butter. But the problem was that when he actually went to his local grocery store to claim the butter, he had to hand in a slip of paper with his name on it. And he objected to that. He said, well, it's actually not really the grocer's business to know who I am and that I am personally a person entitled to this free butter. So he contested that, and he wanted to keep his name private. We can already see that he has failed miserably on that count, because his name is nowadays in every textbook on European Union law. But sort of for the sake of the principle, he fought that through and went to the German courts, who asked the question to the European Court of Justice. And the European Court of Justice said, well, actually, as a matter of European community law at the time, it was not compulsory to require him to put his name on that slip anyway. That was rather because the Germans were so particularly thorough when they implemented that they actually made him write his name on that slip of paper. So as far as European community law is concerned, there is actually no interference with any of the, as the court said at the time, fundamental human rights that are part of the general principles of European community law, which the court has to protect. In this sort of masked language, fundamental rights made their entry for the first time into European Union law, and it was indeed, as we can see, a case of data privacy. It's maybe not a coincidence that the case came from Germany in particular, and it is a case that already gives us sort of an idea of the principle of data minimization. Is it really necessary for the authorities to be in possession of the name? Actually, does the name of that person really have to be passed on for the rules to work? Now, in that way, data protection has made its way into the general principles of European Union law. The fundamental principles which the court has sort of discovered by looking at the common constitutional traditions of the member states and at conventions for the protection of human rights to which the member states were parties, included in particular, of course, the European Convention for the Protection of Fundamental Rights. And Article 8 of the European Convention contains the right to respect for private and family life, home and correspondence. And this certainly includes the right to privacy in a broad sense. So that is one source of European Union protection of privacy at the very highest level of the law, primary law. Another more recent source, which has become a binding source of Union law only with the Treaty of Lisbon, is the Charter of Fundamental Rights. In the Charter of Fundamental Rights, Article 8 gives a more concrete right to data protection. It mentions in particular that those personal data may only be processed fairly and for specified purposes, and on the basis of consent or some other legitimate basis, and those bases must be laid down by law. So these are already sort of the primary law basic principles of data protection, which the European Union legislator must then respect when he decides to implement them by secondary legislation. I should also mention Article 16 of the Treaty on the Functioning of the European Union, which contains a legal basis, a specific legal basis for the Union legislator to adopt measures in the field of data protection. And the legal basis is one that foresees the ordinary legislative procedure, which means that the Commission is going to make a legislative proposal, which is then going to be decided on by the Council of Ministers, the Council of the European Union, and by the European Parliament. On earlier legal basis, the European Union has already adopted a series of pieces of secondary legislation, in particular a directive of 95, which is sort of the current state of European Union law in the field of data protection, on the protection of individuals with regard to the processing of personal data. This directive is, in accordance with the Commission proposal, going to be replaced by the current text, but built on. The second text that we have is a more specific text which concerns the processing of personal data and the protection of privacy in the sector of electronic communications. That's a more specific text clearly targeted towards electronic communication, which will survive after the data protection regulation will have been adopted. Then there is another act on the protection of personal data processed in the framework of police and judicial cooperation in criminal matters, an existing piece of legislation in what used to be the third pillar of the European Union, which follows slightly different rules, and which will be replaced by an act on the general basis for data protection, namely Article 16 that I've just mentioned, in accordance with a Commission proposal for a directive. And finally, we've got a specific act on what the European Union institutions are to do when they treat personal data. And that act, which concerns only the activities of European Union institutions and bodies, is going to survive and will in principle be left untouched under the new Commission proposal. So, in overview, we can say that the current situation is characterized by the existence in the field of general data protection of a directive being a piece of European Union legislation which the member states have to implement. The implementation has been very different in the various member states, and the Commission, when it investigated the need for new legislation, found out that those differences really led to great discrepancies and to the internal market in certain areas not functioning very well. The directive is from 1995. It has hardly been amended, which means, well, it needs to be modernized. The internet was really in its infancy stages when the Commission proposal for the 95 directive was made, and even when it was adopted, so there's not much. It needs to be adopted to modern technologies, adapted to modern technologies. That was one important reason for changing the legislation. And finally, the existing legal basis for this directive is purely internal market oriented, which means that it has sort of a more narrow focus, whereas nowadays we've got a general broad legal basis for data protection, which is this Article 16, on the basis of which you can presumably do a bit more. So what has happened so far and where are we today? In January 2012, the Commission issued a communication and made two legislative proposals. The first one is the one that we are going to focus on the general data protection regulation, and another proposal in the field of criminal law, which we're going to leave aside for the moment, because I think that already the general data protection regulation is going to give us many things to discuss. So once the Commission made that proposal in January 2012, it came before the European Parliament and the Council, who have been discussing it for now almost 2 years already, and the discussions have actually been quite difficult. The rapporteurs at the European Parliament were, on the one hand, Jan Philipp Albrecht from the German Greens, and Greek Dimitrios Droutsas. He was in charge of the directive concerning criminal law. The poor rapporteurs received approximately 4,000 proposals for amendment to the texts from all sides, which was one important reason why it took them much longer than expected before they could draw up their reports. And finally, the committee to which they belong was able to vote on only slightly over 100 compromise amendments to the original proposal on the 21st of October. So actually quite recently, the lead committee in the European Parliament voted on slightly over 100 compromise amendments to the Commission proposal. At the same time, the 28 member states of the European Union are negotiating all this in the Council. And in order really to enter into more concrete negotiations with the other institutions, namely the Commission, which has proposed, and with the European Parliament, they will need to adopt a general approach. They will need to get sort of a common idea of the main features that they want to see in that text, and only then will they be able actually to enter into negotiations in the form of so-called trilogues with the European Parliament. And there is some hope that such a general approach might be found before the end of this year, but this is a bit difficult to predict, I would say. Now, the highest political forum for the member states, namely the European Council, which is comprised of the heads of state and government and the President of the Commission, made a statement at the European Council on 24th and 25th of October, saying that yes, indeed, it is necessary to adopt in a timely manner a strong EU general data protection framework. At the same time, they made reference to the completion of the digital single market by 2015, which might suggest that there was a tension between those who really wanted to go quite fast and those who thought that it was, after all, maybe not so urgent and maybe necessary to discuss the substance a bit more, and which had that reference to 2015 inserted into the text. And I would now like to give you a small overview of what this text does. The data protection regulation pursues a double objective of, on the one hand, protecting individuals with regard to the processing of personal data, and on the other, ensuring the free movement of personal data, which already indicates that the objective is not to achieve the highest and greatest possible protection of personal data. A balance must be struck between privacy on the one hand and free movement interests on the other hand. That is, I think, very important to bear in mind. The internal market and the need for businesses actually to carry out their business is not forgotten in this text. Important definitions are contained, on the one hand, are contained in Article 4, which refers to data subjects, and that's maybe one concept that we should later spend a bit time on. A data subject is a natural person who can at least be identified by means reasonably likely to be used by the controller of the personal data or by any other natural or legal person, in particular by reference to all kind of identifiers. So what is striking here is actually the possibility to identify an individual is mentioned here in a very broad way. The only thing that sort of limits the definition slightly is means reasonably likely to be used. That is a limitation that has been inserted compared with the current text, with the directive, which doesn't contain any such limitation. What are personal data? Well, any information relating to a data subject, another important question of interpretation in here, and other definitions over which I'm just going to go very, very quickly are, of course, the definition of processing, any operation or set of operations performed upon personal data. And then we have got the very important concept, of course, of the controller of personal data. The controller is the person or authority which determines the purposes, conditions, and means of the processing. There's actually no major difference between the current definition and the one that has been proposed here, but it's important to see who that entity of the controller is. And the controller is distinguished from the processor. So whereas the controller is sort of the mastermind behind the processing of the data, the processor is the person or authority who actually processes the data, the one who carries out the activity, very simply. What is it that the regulation is actually supposed to apply to? Well, it is the processing of personal data, but there are a couple of carve-outs. There are a couple of instances of processing of personal data that are actually not covered. What is not covered in particular is national security, because national security is one essential function of the member states, and any data processing that is related thereto is not supposed to come within the scope of European Union law. The union institutions have their own rules, and criminal law has also got its own rules, so we are not going to find this in here. I would like to draw your attention to the territorial scope of the rules, which has been enlarged, and that is of course something which is interesting for operators established in third countries. The data protection regulation is supposed to apply to the processing of personal data of data subjects residing in the Union by a controller who is not established in the Union. Right? So a controller of personal data established, for instance, in the US will have to comply with the European rules where that controller offers goods or services to data subjects in the Union. Right? Very important clarification. I would say actually that's even a new step compared with existing legislation. It is now clear that whenever someone who controls personal data in a third country wants to offer goods and services in the Union will have to comply with European Union data protection legislation. The second case is where the monitoring of the behavior of data subjects in the Union occurs by a controller established in a third country. So first, important innovation here, clarification, strengthening of data protection regulation vis-à-vis third countries. Let us turn for a second to the principles. I would like to turn to them because I think in particular that they are actually quite different from what we have in the US. When you look at this summary of Article 5 of the Commission's proposal, you're going to see that the principle is that the processing of personal data must be limited to the situations in which it is allowed by the regulation. So, no data processing without an authorization by law. This is already in the treaty, as a matter of fact. And this is actually the inverse situation from what we have in the US, right? In the US, you can actually process personal data unless it is forbidden. And maybe, one way of looking at that is to say that the approach towards basic fundamental rights in the European Union and in the US is in the relevant respects quite different. I mean, in many European constitutions and also in the European Charter of Fundamental Rights, the first fundamental right that you find is human dignity. Human dignity and sort of privacy is one of the things that follows from human dignity. Whereas in the US Constitution, I mean, one of the essential fundamental rights enshrined in the First Amendment is, well, freedom of speech, right? So maybe the balance is also for that reason struck a little bit differently in European countries and in the US. Other principles are, well, the transparency, minimization. Actually, you are only supposed to process as many data as you really need, and the liability of the controller. One point to which I would like to turn briefly and specifically is the consent of the data subject that is needed for certain types of data processing. So the regulation actually allows the processing of personal data in various situations. Also when there is a legitimate interest, when there is something which is actually foreseen in national law. But one very important reason for processing personal data at all is, well, that someone has consented to it, right? And the question of when such a consent is present was not very clear in the existing legislation, and therefore it was very important for the Union legislator to foresee that that consent must be given explicitly. Yeah? Where the basis for data processing is consent, that consent must be explicit by statement or clear affirmative action. So when there is something that explains to you that when you click this button you agree to this and that, then it's enough if you click the button. That would be explicit, and but it's an action of the data subject that would then express this consent. A couple of other clarifications have been made, and in particular the Commission has proposed to say, well, consent may not be a basis for processing data at all, where there is a significant imbalance between the data subject and the controller, which is of course a rule that is extremely difficult to enforce, I would say, and also a rule which really places a great burden on the controllers, right? I mean, where the controller is a big undertaking that simply needs to process certain data and asks the data subjects whether they agree with that. The affirmative answer of the data subject should then not be enough for the data to be processed. This is something that the European Parliament has not really agreed to, and it has therefore proposed to delete that provision, while at the same time adding further limits concerning the validity of the consent of the data subject. A very important concept of the regulation was that the rights of the data subjects in general should be strengthened. And you can find in Articles 11 and following of the proposal a whole list of those rights. They must have easy access to the policies of the controller of their personal data. They must get information by the controller which must be clear and in principle for free. They have, and here is where it gets really important, the right to access the personal information, the personal data which are being processed. At any time they can ask, well, what do you actually know about me? What are the personal data that you have about me? They will, according to the Commission proposal, enjoy the so-called right to be forgotten, which is, well, maybe one of the most controversial provisions about which we should speak maybe for a moment, and the right of their data being erased in certain circumstances. And another right is portability, that when they move from one provider to another, they are supposed to be able to obtain a copy of their personal data in an electronic and structured format, which is commonly used to go to the new provider. That I think is certainly also sort of a practical advantage for the data subjects. let's turn more in detail to the so-called right to be forgotten. The principle is already now that where the consent and the other reasons for processing personal data fall away, yeah, the controller actually doesn't need the personal data anymore. The data subject can obtain the erasure of those data. Yeah? Nobody should actually be in possession of the personal data longer than necessary. But the follow-up question is, of course, what happens when the data has already been made public? And here there has been a long debate, and I would say it's actually an ongoing debate on how to deal with these situations. And the Commission has proposed to include this right to have data removed, well, to some extent, maybe even with regard to third parties. At least what the controller of personal data has to do when he receives a request is to take all reasonable steps, including technical measures, to inform third parties of a request for erasure. So that could include, for instance, when there is a source web page which contains personal data, the data subject wants this data to be removed. In that case, the controller might then be required to contact Google or other search engines to remove the relevant links so that the page would no longer be searchable on the internet, on that search engine. That is what one apparently has in mind with this right to be forgotten. It is important to highlight immediately that the right is not an absolute right, because there may be a legitimate interest in the data to continue to be searchable, right? When this is sort of part of an online edition of a newspaper, which has simply put that on the internet together, when it published its printed version, there may certainly be a legitimate interest in the information continuing to be there. Freedom of expression would be one important reason not to respect the right to be forgotten of the data subject. And alternative possibilities than the simple deletion of the data can also be envisaged. Another important issue is the question of profiling, which is also addressed in this regulation. Profiling occurs where data are processed in an automated way with the intention to evaluate certain personal aspects of a data subject. For instance, one could imagine that a health insurance might be interested in knowing whether the risk that it might take by giving an insurance policy to a certain person is actually an acceptable risk, and might therefore collect information about the data subject who has been searching, well, health-related topics on the internet. And one might imagine a data profile of that individual being established in that way. And the regulation would allow that only in certain circumstances. The regulation would in principle prohibit such profiling where it is used as the only basis for a measure which either produces legal effects or significantly affects the person. So when it is about the question whether you're actually going to conclude a contract with the person, I would say, well, that would be a measure intending to produce legal effects, and you can, in principle, therefore not profile, right? Unless you actually enter into the contract anyway. So if the profiling has been used sort of at the threshold as a hurdle for actually concluding the contract, and then afterwards you conclude it anyway, well, then it turns out that it's okay and the data subject cannot really complain. Or in the alternative, there have been other suitable measures to safeguard the data subject's legitimate interests, which could be that actually a human being looks into this data also. Yeah? So it's not just sort of the automatic result where it says, well, no, we are not going to give that person a contract, but there is actually a human being behind this who you can talk to, and it says, well, actually, I've made the assessment based on this and that criteria, and I agree with the result that was the outcome of the profiling. There are a couple of other technical points that I think I'm not going to spend any time on right now. We can, if you want, then return to those in our discussion. One reaction to recurrent data security problems has been the proposed provision that data breaches, violations of data security, data privacy rules, are supposed to be notified by the controller more or less immediately to the competent national authorities, and where that can affect the situation of the data subject, also to the data subject. So where your banking data have been hacked, for instance, the authorities should know that immediately, and you should also be very quickly notified so that you can possibly take the necessary measures. Other points that are sort of reinforced obligations of the controller of personal data are the fact that a controller may have to carry out a data protection impact assessment. So one of the ideas behind the new rules is that one doesn't want the controllers to simply notify everything they're doing to the national authorities, who are then going to store that and not going to do anything with it. What one wants to do, rather, is actually to have the controller of the personal data carry out operations himself in order to ensure that the rules are complied with. And such an impact assessment would have to be carried out where the processing operations present specific risks to the rights and freedoms of data subjects. In that case, there should be an analysis of the risks, and corresponding measures should be taken. Another measure in the same vein would be the fact that data protection officers might have to be appointed by controllers processing a lot of data and a certain type of data. What I would like to look at for a moment are the rules on transfers of personal data to third countries. That is, of course, another topic which is particularly interesting to the US. There are rules which are proposed to be enshrined in Articles 40 and following of this regulation. And the principle, as a matter of fact, is unchanged. Already, under the current Data Protection Directive, Article 25, Article 26, personal data may only be transferred to a third country where that third country ensures an adequate level of protection. So you're not going to look at, in principle, you shouldn't be looking at whether the third country has got exactly the same rules as the European Union, but you need to make sure that in that third country there exists an adequate level of protection of those personal data. There are no dramatic changes in the legal text, even though in the literature it has actually caused quite some excitement as far as I can see. What has been done, what the Commission has proposed was, well, actually to reinforce its powers to make adequacy decisions. So the Commission is able to say, this is a third country which has such adequate protection, or this is a third country which does not have such adequate rules. And the Commission is going to carry out that assessment in the light of certain criteria, which are, well, the rule of law. Is the rule of law respected in the third country in question? The relevant legislation, the existence of effective remedies in the third country, the question whether there is an independent supervisory authority, and also the international commitments to which that third country has subscribed. But the fact that you don't have such an adequacy decision doesn't mean that it's over and you will never be able to transfer the data to a third country. As a matter of fact, there are other appropriate safeguards that may be used and that may justify such a transfer. And among them are what is called binding corporate rules, standard data protection clauses, or contractual clauses. This is something on which the current directive is completely silent. However, the Commission has been working with the Member States and with the authorities of third countries in the background and has produced a framework which looks actually very similar to what is in reality therefore being codified right now. Binding corporate rules would justify transfers of personal data within a company. Yeah. For instance, you as an individual in one European country send your personal data to a branch of a company which is established in the US, and the transfer from that, which is established in that European country, and the company itself has its seat in the US. So once you have transferred the thing to that branch, when there are such corporate rules for that company, the transfer to the seat of the company in the US, for instance, might be justified. And such rules have been worked out in very close cooperation with, in particular, the US. Another possibility are standard protection clauses and finally contractual clauses. So when the data subject and the controller of the personal data conclude a contract for which there are model clauses, which will then ensure that there will be an adequate protection of the personal data. And that has been actually the basis, these different mechanisms have been the basis for the so-called safe harbor clauses, and the safe harbor decision of the Commission, which exist concerning the US. What happens there is that there is a certain voluntary self-certification program for US companies. That program is monitored by, inter alia, the Federal Trade Commission, and where a company is actually on that list and says yes, is certified, transfers to that company in the third country in the US may take place. And that is actually not going to change. The Commission has proposed that all these decisions concerning the corporate rules and the safe harbor are going to continue to apply under the new regime. It gets a bit more delicate when one looks at the European Parliament, because the European Parliament actually proposes the existing clauses and the existing decisions to sunset. Yeah, so after 5 or 2 years in the different cases, it might be that it's over, and by that time the Commission would have had to evaluate all that afresh. We're going to see where the legislative process is going to take us on that important issue. Even when you don't have anything of all this, it may still be possible to transfer data to a third country on the basis of a limitative list of derogations. But that list of derogations actually contains something quite generous, namely the possibility to transfer data to a third country where the transfer is necessary for the purposes of the legitimate interests pursued by the controller or the processor, which cannot be qualified as frequent or massive, and where the controller or processor has assessed all the circumstances surrounding the data transfer and, based on this assessment, adduced appropriate safeguards with respect to the protection of personal data where necessary. So there is actually, the Commission proposes a very big opening clause for transfers, even sort of on an ad hoc basis. So I would submit that if the Commission proposal goes through on this point more or less unchanged, there is actually no real reason for third country companies in a country like the US to worry too much about the possibilities of data transfer. Another rule which is actually quite generous, I would say, to companies is the rule which foresees the so-called one-stop shop principle. You must know that in the 28 member states, there are data protection authorities, data protection supervisory authorities that apply this regulation and that have to monitor, of course, the behavior of anyone who controls personal data. And the supervisory authority, which is competent in the case in which a controller or processor is established in more than one member state, will be the one where the main establishment is located. That is the idea of the European Commission here. It should be, when you're active in several member states, it should be sufficient for you actually to be supervised and to have your actions controlled and approved by the supervisory authority of one single member state, the one of your main establishment. That is, of course, very nice for businesses, but it is maybe not always so nice for the data subject, because, well, the data subject, of course, would like to have the control as close as possible to where he is, right? And therefore, in the Council, as a matter of fact, a number of member states have said that they are not entirely happy with a strict one-stop shop principle and would like to, well, to bring this closer to the citizen. And, well, a couple of possibilities for doing that have now been envisaged. Because we must take into account here that the supervisory authorities in the member states supervise, of course, what the companies are doing, but at the same time there may also be complaints from individuals. So another way of getting a supervisory authority involved is by actually going there and complaining about the behavior of a certain company. And most naturally, the individual is going to prefer going to the supervisory authority in his or her own country. And how do you balance actually these different interests here? So after some discussions in the Council, it seems that what we are going to get is, well, the main supervisory authority, the one in the member state with the main establishment, only receiving some powers, more or less centrally, and the rest, nevertheless, being the subject at least to discussions between several supervisory authorities. There could be some form of co-decision between different authorities in different member states. That would be one possibility. Or it could also be that the individual who complains goes to his local supervisory authority, which makes a draft decision dealing with that complaint and submits that draft to the supervisory authority of the main establishment, which would then adopt the decision. I mean, this is a complication that, as you can see, arises from the fact that all this is nevertheless implemented in a federal way by authorities in the 28 member states. What is going to counterbalance, according to the Commission proposal, the fact that in principle you should only go to one single supervisory authority if you're established in several member states, is the so-called consistency mechanism. So in the Commission's proposal, where one supervisory authority that has been determined by the one-stop shop principle is about to make a decision which is going to have a union-wide impact, or something that may be qualified as a union-wide impact, it will have to submit that measure to an entity which is proposed to be newly created by this regulation, and which is the European Data Protection Board. The European Data Protection Board, which will be composed of the supervisory authorities of all the member states and the European Data Protection Supervisor, is going to look at that and issue an opinion. It can then go on to the Commission itself, and this is something which has also been contested by some, the Commission may be put in a position to suspend a measure of a national authority for a period of 12 months at the most. We're going to see whether that will actually go through as such. One possibility that has been advocated by the European Parliament was to give such a decision-making power rather to the European Data Protection Board. The difficulty there being that as soon as such an entity has really some margin of discretion, you cannot outsource those decisions. I mean, if it's really sort of the application of the rules to a very clear individual case, and it's almost sort of a mathematical formula, and the outcome can then be relatively clear, you can say, okay, we can give that to someone outside the core institutional system, such as this European Data Protection Board. But as soon as it involves discretion and sort of a balancing of different interests, this is something that, according to the current case law of the European Court of Justice, cannot be delegated away from the European Commission. So we are going to see what is actually possible in that area. Some important changes have been made to the, or proposed to be made to the rules on remedies, liability and sanctions. Individuals and associations actually for the defense of data protection rights shall be able to complain with any supervisory authority that they choose. And judicial remedies are supposed to exist against controllers or processors at the choice of the data subject, either in the member state in which the controller or processor is established, or in the member state of residence of the data subject. So again, the idea of making it easier for the citizen to enforce his or her rights by being able to choose as a forum for disputes the local courts. Another point which has been emphasized a lot in the debates were the reinforced rules on sanctions. The Commission has proposed, I mean, in any event, of course, sanctions for violations of the rules contained in the regulation are supposed to be, as always, effective, proportionate, and dissuasive. And the Commission has included a provision where it says that, well, for certain violations, sanctions should go up to €1 million or 2% of the annual worldwide turnover of a company, which is probably going to be quite dissuasive. And the European Parliament has actually wanted this to become even up to 5% of the annual worldwide turnover. Once again, we're going to see in which direction we are finally going to move. To summarize, well, first of all, we need to see, of course, when this text is actually going to be adopted. I've already mentioned that we may be looking at, well, some more time for the negotiations. The difficulty there being that the European Parliament is only going to continue in its current composition until June next, and there will be parliamentary elections, and one would really have to hope that one gets these legislative proposals through by that time, which at this time I would say cannot be guaranteed. If it is then adopted, it will only become applicable 2 years later. So everyone will actually have time to adapt to the new rules for another 2 years from the date of entry into force. What we can expect in general, I would say, is, well, better defined rights for the data subjects, simpler procedure for the controllers of personal data, especially when those controllers are active in several member states, and finally, an important contribution, we hope, to the creation of a digital single market. Thank you very much for your attention, and I look forward to the discussion.